Good morning, everyone. Thanks for joining us. Appreciate you being with us. I know you need to get your CLE credit. We hope to give you some update on all kinds of areas of the law this first session on privacy law updates, which is not an easy issue for in-house counsel to advise their internal constituents, trying to keep up with the fluid nature of evolving laws. Just as you get settled with one, a state changes its law or updates, and that is no easy task. We won't be able to cover all of that today. Privacy, particularly numerous state laws and international, is more than an hour, but we hope to give you an overview of the new laws and a little bit on the data breach landscape and some changes in that area. To get us started and give us a little bit more background on our audience, we have our first poll. Make sure that you're conversant with our polling system, as Amish introduced, and that is, you have worked on your company's or a client's privacy policy or other data privacy compliance efforts and or data breach response. I'll give you a few seconds to answer that. Yeah, this is tough because even if you're labor and employment or IP or corporate or transactional, you're likely dealing with some intersection with data. So even if you don't have sort of first line responsibility for privacy, it probably intersects with what you do and what you're doing with your clients and constituents. All right, looks like we're at 100% and 72% of you said yes, which is good. You'll have some familiarity with the things that we're talking about today. And hopefully we can educate you on a few new things and help you answer those questions for your folks. To get us started, I'm going to turn it over to Carmel, who's going to give you an overview on the current data breach landscape.
Thanks, Rob. Before we dive into the data protection laws and regulations in the US, let's start at the point during which data protections and cybersecurity methods fail: data breaches. Could go to the next slide. As you know, a data breach is classified as one because there is a confirmed disclosure of an individual's personal data to an unauthorized party, usually an external actor. All US states and DC and US territories have their own breach notification statutes governing whether the personal data or information disclosed is protected, as well as the requirements for providing notice of that data breach to affected individuals. Next slide. So what falls within the definition of personal information, or personally identifying information, known as PII for short, is largely state or territory specific. It usually includes the name of the individual, as well as sensitive, unencrypted data elements, such as the categories listed in this slide. Personal information usually does not include any de-identified information, because de-identified information generally cannot be tied back to a person or used to identify the person. Another category of information includes pseudonymous data, which is data that has been anonymized but can be re-identified with a data set that is kept separate from the pseudonymous data. Pseudonymous data is often treated as personal information simply because it can be re-identified and thus tied back to an individual or household. Next slide. However, some states define personal information more broadly to include more sensitive data categories, such as those listed on this slide. The key here is, can any representation of information on its own or combined with limited other data be reasonably inferred to identify the individual by any direct or indirect means? Next slide. Now, additionally, personal information generally does not include information concerning an individual's workplace, like their job title, any business telephone number, and information put out there by the individual on social media sites, and also IP addresses and cookies tied to any personal or work computer or mobile device. And now it's time for another poll. What percentage of data breaches involve a human element such as employee error? Just a reminder that if you have requested CLE credit, you must respond to each poll to verify your attendance, so be sure to submit your response. So we'll be getting into this more in the next section, but let's take a look to see what folks suspect. And it looks like 60% of you have picked over 80% of data breaches involving a human element. Let's find out if that's the case. Next slide. So now let's talk about the Verizon 2022 Data Breach Investigations Report, or DBIR for short. The 2023 report is not yet out. So let's note that the Verizon 2022 DBIR distinguishes between incidents and breaches. Again, an incident is a security event that compromises the integrity, confidentiality, or availability of an information asset. But a breach is an incident that results in the confirmed disclosure, not just potential disclosure or exposure of data to an unauthorized party. So basically, every breach is an incident, but not every incident is a breach. The relevant time period for the DBIR is November 2020 to October 2021. And out of almost 24,000 incidents, about 5,000 of those resulted in a confirmed breach. The DBIR also discusses how, over the past year, ransomware attacks increased by 13%. Ransomware attacks usually were the result of 4 paths: compromised credentials, phishing, exploited vulnerabilities, and botnets. Botnets, for those of you that do not know this term, refer to a group of internet-connected devices which are used to perform attacks such as a denial of service attack, send spam emails, engage in social engineering, and click fraud campaigns and the like. As the DBIR discusses, blocking those paths will block the level of exposure to ransomware that may enter a business system from an external actor, which then limits the breadth of negative consequences. Next slide. The DBIR also notes that external attacks accounted for roughly 4 out of 5 breaches. External attacks are powered by the actor's motives. Unsurprisingly, financial gain has been the top motive that the DBIR has tracked since 2015. Other motives include hacktivism, particularly leaks, and espionage. Hacktivism was seen to have started back in 2011 against larger organizations worldwide. But the bottom line is that external actors are mostly professional criminals motivated to make money from the information and access that they obtain. As for the human error of it all, the DBIR noted that 82% of breaches in the 2020 to 2021 time period resulted from a human error, falling victim to phishing, social engineering, misuse, stolen credentials, and the like. The median number of assets compromised by an insider breach or a breach caused by an internal actor through human error exceeded that of a breach brought on by an external attack. It was more than 10 to 1. So these assets include servers and persons and their devices. The servers affected include internet-facing assets such as web applications and email. As to the effect on critical infrastructure, known as operational technology, these incidents accounted for approximately 3% of the overall incident data, which may not sound like much, but it is a 1% increase from 2020. Next slide. So let's talk about specific industries affected by breaches and incidents that were highlighted in the DBIR. First up is the professional, scientific, and technical services industry. These industries were affected the most by DOS attacks and external attacks with internal and partner actors. DOS attacks, you may be the most familiar with these. These attacks are intended to compromise the availability of networks and systems. This includes both network and application layer attacks. The DBIR refers to this as the actor's attempt to create a traffic jam in the pipes. These were the most common. 100% of DOS attacks were confirmed to be external. The DBIR in total looked at 8,456 incidents in the professional, scientific, and technical services industries, and it found that the median DOS attack lasted less than 4 hours, and that the vast majority of organizations that are monitored for these attacks experience less than 10 attacks a year. If, on the other hand, you are one of those unlucky 1% of companies that experience more than 1,000 DOS attacks a year, you're probably already aware of this and most likely have a service to help you manage the traffic. The suggested top controls to protect assets included security awareness and skills training of employees, controlling access to information, and securing the configuration of your assets and software. Next slide. In the manufacturing industry, the DBIR looked at about 2,300 incidents, with about 300 of those resulting in a confirmed data disclosure. The usual suspects for breaches in this industry are the same that seem to appear across other industries: stolen credentials, ransomware, and phishing. Financial actor motives dominated breaches in manufacturing and resulted in about 88% of those breaches. Next slide. Now let's talk about the financial and insurance industries. With 2,527 incidents reviewed and 690 of those confirmed with data disclosure, the DBIR discussed how the financial sector continues to be victimized, unsurprisingly, by financially motivated organized crime, often through the actions of social engineering, hacking, and malware. In 2016, servers were involved in 50% of the financial industry breaches, as opposed to 90% in this latest DBIR. However, the specific variety of server or web application has increased from 12% to 51% over that same time frame, thus accounting for basic web application attacks position in the top 3 patterns looked at. A key component of these attacks is that they usually involve the use of stolen credentials. These credentials may have been stolen in any number of ways, but brute force hacking and credential stuffing are the most likely culprits. Next slide. Now let's talk about some of the data breaches that happened in 2022. First up, we have the March 2022 MailChimp breach. MailChimp is a marketing automation platform and email marketing service based in Atlanta, and they discovered in late March that there was an external malicious actor who accessed a customer support and account administration's Teams tool by way of a social engineering attack. Although MailChimp terminated access to the compromised employee accounts after discovering the breach, MailChimp found that 300 accounts were accessed and data from 102 accounts were exported. The news of this breach was initially reported by one of MailChimp's cryptocurrency industry customers, when users of that customer service reported receiving phishing emails. The phishing emails prompted those users to reset their account credentials and download malicious software. MailChimp's internal tools were actually breached again this past August 2022. And in that latest MailChimp breach, a cloud infrastructure company that was a MailChimp customer reported that its customer base, their customer emails and addresses were accessed and obtained. The cloud infrastructure company performed its own investigation after discovering that customer email passwords were being reset without consent. Their two-factor authentication saved a handful of customers whose emails the hackers had targeted. Speaking of hacking, let's go to the next slide. So let's talk about a breach resulting from hacking. In January 2022, a third-party vendor of OKTA was compromised by an external actor, resulting in the exposure, access, and control of an OKTA employee workstation. OKTA initially shared in March 2022 that a maximum potential impact included 366 organizations. However, after closing its investigation in April 2022, it reported that the external actor controlled the OKTA employee workstation for 25 consecutive minutes. During that 25-minute window of time, the actor accessed information of 2 of OKTA's customers and viewed OKTA information in other applications, such as Slack, that were separate from the OKTA customer servers. So following this breach, OKTA committed to taking actions on 3 specific fronts. The first being third-party risk management, second being access to customer support systems, and third, customer communications. As to the third-party risk management, OKTA pledged to strengthen its audit procedures of its sub-processors so that the sub-processors would comply with OKTA's security requirements. As to access to customer support systems, OKTA pledged to manage all third-party devices that may access customer tools and restrict the information available to third-party sub-processors. And finally, as to customer communications, OKTA pledged to adopt new systems to help it communicate more rapidly with its customers on security and availability issues. And let's talk about our last breach in this section, to the next slide. A breach resulting from social engineering. So in September of 2022, a hacker socially engineered an Uber employee after somehow discovering that employee's WhatsApp number. The hacker contacted that employee via message and instructed the employee to log into a fake Uber site and quickly grabbed the credentials that were entered in real time and used them to log into the genuine Uber site. Now, Uber did have multi-factor authentication in place in the form of an app on the employee's phone where the employee would have to push a button on the smartphone when logging in. But to bypass that protection, the hacker repeatedly entered the credentials into the real site. The employee, who was apparently confused or fatigued, eventually pushed the authentication button, and with that, the attacker was in. So that concludes our review of data breaches in 2022. I'm turning it over now to Rob, who will discuss the US landscape of data privacy laws.
Thanks, Carmel. If we could go to the next slide. All right, and before we launch into this, it's time for our next poll, see your general awareness. And this is a 2-parter. First question is, Virginia was the 2nd state behind California to pass a comprehensive data privacy law. And the second question, there's currently no federal comprehensive data privacy law. I'll give you a few seconds to answer that. One thing you'll say from today's presentation is not a lot on North Carolina specifically. North Carolina has a bill still in process to update its privacy law. That may get some more traction this year, yet to be seen. There's certainly interest in it, but it's got hung up on a number of different things. And the bill from 2021 and revised last year does not include a private right of action, which is generally a good thing for you defending these. Okay, we've got our answers. I think everybody's had an opportunity, and most of you have gotten this right. Virginia is the second state to pass a comprehensive law, and yeah, just about all of you got that there is no comprehensive federal data privacy law, which makes this all complicated, and why we're talking about so many different state laws today. We can go to the next slide. All right, so these are some of the laws we'll touch on today. As mentioned, the states on the left, California, Virginia, Colorado, Connecticut, and Utah, really have comprehensive data privacy legislation. That said, there are a number of bills and states that have more narrowed laws, but that touch on this area. From my general sense of who's attending this, you have some compliance obligations from residents in these states, and that's how it's determined. It may not be that you're located in the state, but if you have data that involves a resident who lives in one of these states, that is the threshold generally, particularly for reporting obligations for data breaches, as Carmel just mentioned. All right, let's go to the next slide. All right, certainly California gets the most press and notice because it has the most comprehensive data privacy and a number of consumers that people generally have to comply with. And just when we were getting ready to understand the law surrounding CCPA in 2020 and beyond with the rulemaking that occurred, CPRA has now just become effective. And CPRA has some overlap with CCPA, but there's some changes that I'll talk about, and its enforcement regime is more significant. The CPRA draft regulations are not fully implemented. If you're familiar with California privacy law at all, not only do you have the draft law, but it allows the Attorney General to implement rules to follow it, give some guidance and suggestions about some of the terms and the requirements. And that makes it complicated because you're waiting for weeks or months to figure out, well, how stringent really is this and what are they going to do? CPRA, the most significant obligations obviously are that businesses that are subject to it have to have privacy policies with specific information, what information you have, what are you collecting, how do you use it, and providing consumers all sorts of rights to know what data you have and the ability to delete it upon request. California, as we'll talk in a minute too, also has a private right of action. So consumers who believe they were wronged or their request wasn't granted, or frankly, we've seen some enterprising plaintiffs' attorneys have already started to try to take advantage of the private right of action, inserting individual and sometimes even pled as class action matters. Let's go to the next slide. All right, so first of all, the determination must be, okay, does this apply to me? Do we have to deal with California? Some companies have made kind of a smart choice in saying, well, it may or may not, but it may in a year or two. But if we can comply with California, then we're generally going to be okay with most other state laws. And that's right. But the thresholds are there. You may have had to analyze this. The laws were initially passed for big data companies, the Googles of the world, Facebook, that kind of thing. So the thresholds for smaller companies may not get you there, but the notion that you don't have offices or people in California is not the requirement. If you have data that affects California residents, and particularly if your revenues are in excess of a certain amount, it's going to apply. The only probably good thing for companies under CPRA was the update of annually buys, receives, or sells requirement to 100,000. But that's the threshold initial question that needs to be asked. Okay, next slide. All right. Oh, I think back one to 19. Sorry, yeah, maybe I went too fast there. So let me just go through some of the general changes between CCPA and CPRA. One of them is in opt-out requirements. And when it comes to opt-out requirements, CPRA extends consumer rights beyond CCPA. CCPA only allowed generally for consumers to opt out of selling personal information. CPRA gives them the right to prevent businesses from sharing it. And the definitions of sharing are broader and expanded. It also, CPRA sharing can include profiling about a consumer's behavioral across sites or apps. If you're familiar at all with GDPR, which is not a subject for today, the analytics of figuring out who your consumers are and how they purchase has really become part of personal information. So don't discount that when you're trying to determine what your PII may be and how you're protecting it. The CPRA will also enact rules preventing businesses from collecting additional information beyond what is necessary for processing opt-out requests. So you got to be careful in your verification of data requests to make sure that information isn't maintained. A few other things. So consumer requests, the categories of types of personal information, the collection sources, and third-party access. So consumers have the right to know the categories of third parties to whom the business is disclosing personal data. And there are new obligations, particularly with children or younger consumers, and the right to delete. And essentially the answer on if California applies to you and you have not updated your privacy policy in probably the last 6 months, that's something that you're going to need to take a look at. This CCPA has had similar requirements, so if you are generally up to speed with that, you may be a good way to complying with CPRA. But you need to take a look at the data that you have, how you're processing data subject requests that you may receive. Okay, next slide. Okay, so when CCPA was first announced, there was some leeway, some time before enforcement kicked in. But now those timelines have passed, and California, particularly with the new enforcement regime and agency, are starting to really enforce this. And I think that will increase even more under CPRA as time goes on. So Sephora is an example of one of the first enforcement measures. And you can see here what Sephora was found to have done: failed to disclose to consumers that it was selling their personal information, failed to process user requests to opt out, did not cure the violations within the 30-day period, that cure period. And you may have noticed the do not sell my personal information links on websites that you're going to. The key there is whether a consumer has entered a global privacy control, which allows them to make a global choice, not specific to a site. And Sephora did not honor that. And that is a tricky thing for companies to make sure they recognize and can honor that. We can go to the next slide. It's also worth noting that while Sephora had the 30-day cure period, that is now gone under CPRA. So that sort of quick safe harbor and 30-day period is no longer part of California law. And, you know, data breach, you're getting hit twice, right? You are the victim of a hack and then now follow-on regulation. And in Sephora's case, and where things like their failures are found, these are the penalties they face. And they had to take certain kind of injunctive and prescriptive relief, but also had to pay $1.2 million. So California and now other states are following, even if it's by the Attorney General, to go after folks who are not complying. Okay, if you go to the next slide. All right, and quickly before I hit Virginia, I wanted to also mention the fines under California and other state laws have increased, and particularly for children's consumer data, which is important. All right, Virginia, you guys mostly correctly identified that Virginia has the second comprehensive data privacy law in the country. A lot of the same things apply here. The CDPA, unlike California, does not include rulemaking. So we can sort of reasonably rely on the text of the law itself at this point. A lot of the same things about opting out, the right to correct inaccuracies. All of these laws give consumers much more power over their own data and what they can ask to be deleted or to find out what you have. All right, we can go to the next slide. All right. And here are the other ones. I'll talk about some of the similarities. Colorado's, again, the most important thing is these laws are now in effect. Only been about 6 months, but if you have data and overlap in Colorado, Connecticut, Utah, these new laws are going to apply to you, and you need to follow them. We'll talk about some of the similarities. I think we're on to our next poll. Pause here for a moment. Okay, just make sure you're still awake, getting your CLE. All comprehensive data privacy laws that have been passed at the state level, discussed today briefly, include a private right of action. All right, I'll give you a few seconds to answer that. Looks like we're just about there. This has been the single most difficult issue in lawmaking that legislators have disagreed about. All right, looks like we're there. 37% of you said true, 63% of you said false. Correct answer there is false. Most state laws do not have a private right of action, which is how, frankly, they were allowed to pass. That has been a hang up with a lot of state laws. Virginia, as I mentioned, does not have a private right of action. We go to the next slide. So that said, you're not off the hook because attorneys general have the power to enforce those state laws. Here are some of the threshold requirements, similar to California, where there's a revenue requirement or a data requirement. Similar use of controllers, processors. Controllers is the entity that owns the data. Processor is the one that is managing, hosting, somehow using the data for the business. Okay, next slide. All right, some of the similarities that I mentioned, and again, only sort of touching lightly on these. The state laws require privacy notices and policies. So again, even if California doesn't apply to you, you need to be looking at your privacy policy, what your disclosures are to make sure you're up to date. Sale of personal information, it's a more limited definition than what's in California, but that's something you need to determine. How is sale defined? What is a transfer? You may not be getting money back, but is there some quid pro quo? And again, similar rights granted to consumers on opting out, the sale of information, targeted advertising, etc. Okay, next slide. All right, some additional similarities and importance here. Consent, and that's required in Virginia, Colorado, Connecticut on the processing of certain sensitive type of personal information. So if that's the type of data that you have, you have an extra burden and you need to pay attention to that even more. And all of these laws require you to update your contracts with your vendors. Anybody that's touching that PII, you need to have, similar to California, you may have some experience this with GDPR, sufficient contract and obligations to protect it. Okay, next slide. All right, some additional similarities, and these are things hopefully that you're aware of, that you have or have been considering. Data impact assessments required under most of these laws. No private right of action, but enforcement. Again, as I mentioned, the attorneys general are empowered even when a private affected consumer can't go after you. This is an important thing the attorneys general like to do because it is pro-consumer and the fines can add up. So that is something you need to be paying attention to. Okay, next slide. All right, key differences here, slight differences I've already mentioned on what is sensitive personal information and the treatment of children's information. Some states defer to COPPA and let that federal regime cover it. Others have specific notification and protection requirements for children under 13. And these are things where companies can really get in trouble. And we're going to turn to the FTC in a moment with Carmel. All right. And I think we have one more poll here. All right. And this is to see if you're paying attention to some of Carmel's talks early. Processing or collection or use of synonymous data, which is any personal data that cannot be attributed to a specific natural person without additional information, does not require the same level of compliance as personal data. True or false? And then as a segue into our next section, what agency is primarily responsible for enforcing data privacy issues at the federal level? Homeland Security, FTC, Department of Justice, NASA. The answers are in. The first question is a little tricky. The answer is false, and Carmel touched on this. Pseudonymous data may be better protected initially than personal information, but it can be personal information because you can convert it to personal information. You can sort of make it not anonymous. It is not completely anonymized. So that's a tricky one. And most of you got the right answer. That is the Federal Trade Commission, FTC, who enforces this. And that's a perfect segue back into Carmel, who's going to touch on that topic.
Thanks, Rob. Now let's talk about the concerns that the FTC has forecasted in the past year. So we can go to the slide after that. Great, thanks. In August of 2022, the FTC issued an advance notice of proposed rulemaking, also known as an ANPRM, with a list of specific questions pertaining to surveillance threats by commercial actors. Among the targeted groups are young users, children, And the FTC's questions in the ANPR are targeted towards children, address 5 issues relating to, first, the value of default privacy protective settings. Second, the need for heightened protections for kids on platforms that are not necessarily directed to children. Third, the effects of online designs that prolong kids' online activity. Fourth, the merit of enacting safeguards that distinguish young users of varying age groups. And fifth, the harms stemming from targeted advertising to kids. Let's go to the next slide. On the other hand, the FTC's questions in the ANPR directed towards consumers generally deal with concerns about collection, analysis, and monetization. So for collection, the issue is that only a small fraction of consumer information that companies collect is proactively shared. The FTC is concerned about company incentives to track and surveil consumer online activities as much as possible. As to analysis, the algorithms and automated systems that are used to build consumer profiles and predict consumer behavior and preferences without regard for context. As to monetization, that's the selling of large troves of consumer information through massive, opaque markets for consumer data for use in behavioral ads and advertising. So there's also a concern relating to the issues listed in the slide I'll touch on some of them, for consent or retaliation. That's requiring people to sign up for surveillance as a condition for a service or to pay a premium to keep their information private. Is that really consent? For surveillance creep, it's when companies reserve the right to change their privacy terms after a user signs up. As to inaccuracy, that's when companies do not publicly disclose how their algorithms work, so consumers rarely get a chance to review or dispute any analysis about their data. We can go to the next slide. So known as the notice and comment rulemaking process, typically the FTC engages in rulemaking by publishing a notice with a proposed text of the rule, which explains the FTC's reasoning, and they ask for public comment. The public can respond to an ANPR, and by responding, they can also attend at an informal hearing. The FTC has gone through this process before. For example, in 2012, the FTC approved revisions to CCPA regulations and broadened the definition of protected information to include photos, videos, geolocation information, as well as online cookies. The deadline to submit comments to the FTC's trade regulation rule on commercial surveillance and data security was extended to this past November 2022. It was originally set for October, and over 11,000 comments were submitted. There were many nonprofit entities that made comments to the ANPR, including the Electronic Privacy Information Center. They have been pushing for the FTC to issue a data minimization rule to ensure that companies only collect personal data that the companies need to provide customers with the goods and services that they request, and collections and uses of personal data that go beyond what consumers reasonably expect should be prohibited. They also made some comments asking the FTC to prohibit discrimination for consumers exercising their rights as discrimination as an unfair trade practice. And finally, they've pushed, one of the other comments that they've pushed is that the FTC should issue an algorithmic fairness and accountability rule to require companies to establish that their decision-making systems are effective, accurate, and free from impermissible bias before that they're used, and ensure that companies give meaningful notice to consumers about the use of those algorithms and decision-making systems. Next slide. So next, let's talk about some cases brought by the FTC. First up is a case that the FTC settled. At issue in United States versus WW International Inc. was Weight Watchers, WW's subsidiary's failure to comply with CCPA. That subsidiary failed to notify users of the categories of children's information that it was collecting, and it failed to obtain verifiable parental consent to access the application, such that children were able to bypass the application screens and put in their own personal information, including health and biometric information. The app was structured also so that the privacy notice was hidden and hard to find in links. So parents and guardians would not actually see the notice, which fell short of the direct notice requirement under CCPA. Next slide. Next, we have the FTC versus Kochava Inc. In this case, the FTC's complaint falls under Section 5A of the FTC Act, which prohibits unfair or deceptive acts or practices in or affecting commerce. The FTC alleges that Kochava violated Section 5A by acquiring consumer precise geolocation data and selling that data in a format that allows purchasing entities to track consumer movements to and from sensitive locations with accuracy in location and time. Kochava's business does include being a location data broker that collects information about consumers by purchasing data from other data brokers to sell to its own consumers. Some of the geolocation data that Kochava was selling at issue included specific time-stamped latitude and longitude coordinates showing the location of consumer mobile devices. Another issue that the FTC identified in its complaint is that Kochava provided public access to consumer location data. That is, because Kochava is a data broker, they have an online data marketplace that is publicly accessible. So a potential purchaser could access a free sample from the Kochava data sample and then later decide if they want to engage in paying the monthly subscription fee. So that data sample access was easy for entities to engage with, and there were minimal steps and no restrictions on usage of the data sample. So for example, accessing data via the AWS Amazon Marketplace. The precise information that Kochava sells includes a customer's mobile advertising ID or MAID, and that information is not anonymized. Thus, a data broker could match a consumer's MAID with offline information, such as the consumer's name and physical address. The FTC further alleged that Kochava does not employ technical controls to prohibit its customers from identifying consumers or tracking them to sensitive locations, like churches, hospitals, other places that an individual would assume having some sort of privacy by going there. And to date, Kochava has filed a motion to dismiss, which the FTC has opposed, and the motion is currently before the court. And now I'm going to turn it back to Rob to talk about a congressional potential attempt.
All right, next slide. So our final topic briefly here is on federal data privacy regime or law. And I think from the polling that you've already answered, you know that there is no such law yet. We can go to the next slide. All right, so the maybe the best opportunity for a federal law happened just recently in 2022. The American Data Privacy and Protection Act, ADPPA, was introduced and started out with a bang, with an impressive bipartisan vote out of committee, where people who, like me, who have tracked this for a while, were a little encouraged that something might happen. But unfortunately, it stalled. And folks from both sides of the aisle have had problems with it. And unfortunately, that momentum slowed down. And now, of course, we're into a new Congress, more divided, and not great chances necessarily for it to pass. Some of the key folks who raised objections last time are no longer in the majority, but the opposition still stands. Go to the next slide. The federal bill that's proposed is pretty broadly applicable. It divides covered entities into categories that define compliance obligations. So it's really based on size and the amount of data that you have. If you're a large data holder, you have more obligations, more relaxed for smaller businesses. And that flexibility is probably pretty good. Bigger companies who have more data probably should have more obligations and can typically afford it. Similar to state data privacy laws, the federal law would require that those covered entities post privacy policies with specific information, limit collection to only what is needed, similar things to what we've talked about today. The law would also grant rights to consumers relating to their personal information, such as the right to access, correct, and delete, that are found in a lot of the state laws. One key difference is that it does include, at least in the bill, a private right of action. And we can go on to the next slide. So the problems that people raised with the federal law, the ADPPA, kind of boiled down to whether it would preempt state laws and whether there would be a private right of action. Those who are protective of their regimes, like a California that have pretty robust laws, wanted to protect that right and say that you could have a federal law, but it's not going to change what we need and want for consumers in California. Others, of course, said, well, that defeats the whole purpose. If we're going to have a federal law that people need to comply with, that should take the place of this patchwork of state laws that people need to consider. So that was one. The other is on the private right of action. That's a real divide. And the states that have been able to pass it, as we've seen, including like Virginia, have resolved that and decided there should not be a private right of action, but robust ability for enforcement under attorneys general. That is part of the bill, but I think will be one of the hangups that, if it stands, may not lead to a federal regime. Which is tough, because in this arena, it would be nice to have one law that's static, that everybody could know what their obligations were. It wasn't changing. It wouldn't change based on a new state and residents and consumers that you picked up. But I'm not very optimistic that it will pass anytime soon in the divided Congress we have. It did again pass. There are some core folks in Congress who are big supporters of this and understand the burden that the current privacy regime imposes on its business and constituents. And so I think there's motivation there. I'm just not as optimistic it will get done, or at least anytime soon. I think we are at the end of our presentation. Let's go to the last slide. And I think, Carmel, you can correct me if I'm wrong, that I've left a couple minutes for questions.
Yes.
And do we have any questions so far?
Looks like we have one question so far. So if you have any questions about what either Rob and I talked about, or anything that we can try to give you advice on in this limited time, please enter it in the question and answer box below. I'll just read out the first question that we did receive. What has liability looked like for companies where a breach was not due to company negligence or misconduct? You talked about this briefly, Rob, about there being kind of, two hits there in the regulatory and
Right.
civil
Yeah.
context.
So that's a tough one. So, you could defend yourself by saying we weren't negligent. Unfortunately, particularly when you're looking at, going to trial in front of a jury, it can be looked at as sort of strict liability. If someone was able to get into your system, necessarily you must have had some negligence. And frankly, the company may have policies, but their employees messed up, as we saw with human error before. So it's certainly a defense. The better defense is that the breach didn't happen on your watch or at your company. It was a vendor who you've got a robust agreement with and great indemnity. So they are on the hook. Even if you're the controller, you passed on the responsibility to that vendor or processor, they were responsible for it. Companies certainly have defended themselves, and those are, affirmative defenses or defenses that we raise to litigated matters and actions. But if somebody was able to get in, it's hard to show, particularly on a negligence standard, that there wasn't some form of negligence. That's a good question.
Right, and just to add on briefly to that, of course, depending on the situation, there will still be regulatory liability where companies will need to comply with the applicable breach notification statute, even if the data was managed in-house or by your sub-processor in the specific circumstance. So it, like Rob said, it kind of does become a strict liability regime where, even if your company wasn't negligent, there are still actions that you need to take because you're the one who wanted to collect and, process that data.
Looks like we've got another question I saw, Carmel. Will the new proposed CPRA regs require all companies applicable to CCPA, CPRA to read GPC DNT controls? So a global, and the answer generally is yes. So if a consumer has expressed that they don't want to be tracked, that they don't want their data to be taken, it doesn't necessarily have to be to your specific site. They can do it on a global level, and companies need to figure out how to identify and react to that. And that was, from Sephora and others, we saw as an example of where companies were not able to do that. So we talk about privacy policy, some of that infrastructure. It's the internal process of tracking, identifying, being able to delete and respond to consumers. That's another requirement. I think we're at the end of our time. Carmel, is that right? So
yes.
Sorry that we've only got to a couple questions, but please feel free to follow up with us whenever we can help with these kind of issues. Love to hear from you. Appreciate you being with us for our section.